today's video, we will be reviewing Chapter 12 of the text, focusing on corrections alternatives, namely probation and parole. Please follow along on your own computer as I review the PowerPoint in this video. This lecture will focus on Chapter 12 of the text, looking at correctional alternatives, probation and parole. Please take a moment to look at the chart on the first page of the PowerPoint showing the dramatic increase in the adult correctional population in the 30-year period from 1980 through 2009. The first correctional alternative that we will be looking at is probation. So now we have to ask the question, what is probation? Probation is a correctional sentence not involving confinement. It is a conditional release that is used instead of sending a convicted offender to prison or jail. It is used for felony and for misdemeanor convictions because of its cost effectiveness and the ability to keep people from going to a correctional setting. Probation is the most widely used sanction. The United States population of probationers is somewhere around 5 million people at any given time. That means that almost 2% of the American population is on probation. The factors that lead an individual to being placed on probation mostly revolve around the court proceedings, but also some input from the police. The most important factor is whether or not the person engaged in a plea deal with the prosecutor. The ability to offer someone a probated sentence as opposed to a period of incarceration is a very important tool for prosecutors. It allows them to clear many cases very quickly by offering an alternative to incarceration and an alternative to a trial. Further aspects of the court proceedings influencing the decision to place someone on probation are first the pre-sentencing report, as we talked about last time in class, which is typically produced by a probation officer and then presented to the court to give the court a clearer picture of the life and social place of the convicted individual. This allows the judge or the jury to tailor the sentence more specifically to the present convicted offender. If they have had issues in the past, potentially facing abuse themselves, or they have uncertain living situations, those things should be taken into account when we're making a decision to place someone on probation. Also is the prosecutor's recommendation, how they feel about the circumstances of the guilty act, the demeanor of the person and their of the convicted offender and their encounters with the individual. As we've seen in the past, prosecutors have a lot of discretion with the outcome of a court proceeding, and the decision to place someone on probation or not is no exception. Further, you have the community reaction. Does the community want to see this particular offender or this particular type of offender incarcerated? Would they prefer them to serve their sentences in the community, potentially giving them the opportunity to offer restitutions either through community service or through monetary restitutions? Both of those things are much more difficult to engage in when the person is incarcerated in a correctional setting. So the community's perception of the offender and of the offense is also very important in this process. Additionally, much like the community's reaction, there are certain political considerations that go into this. Some of them are less legitimate than others. As we've seen, the effects of an election on a prosecutor or a judge can impact the decisions that they make as regards to the sentencing recommendations for offenders they are processing during those election periods. Additionally, the community's response can play heavily into how a particular offense or offender is perceived by the political system. Intense community response will typically be mirrored in a political response. More so if the political actors are engaging in an election year, but certainly there is a heavy influence of the political system when those individuals, representatives, council members, executives, mayors, governors, when they see a response from the community. Additionally, there are some practical matters of the court operations that make it necessary for the plea bargaining process, the assembly line process of justice to continue. Most courts in this country are extremely backlogged. Some of them months, some of them potentially years in backlog. So having a process by which new offenders coming to the attention of the system can be processed quickly is very important. To the same point, as the courts are backlogged, many correctional institutions are backlogged as well. There are overcapacity contributing to the unsafe environments of these facilities. So someone could conceivably be sentenced to probation when they maybe should have received a period of incarceration because there's no space to house them. The last element that we will talk about, not necessarily the least, is the judge's discretion. How the judge feels about the particular offender, the truthfulness of their accepting of what has happened, how they interpret the pre-sentencing report. There are a lot of factors that go into a judge's decision to give someone a particular sentence in any given court setting. There are several types of probation that can be imposed upon an individual. The first and most common is defined as straight probation. That is where there's not. This is basically the process that you would think of when you think about probation. You don't go to incarceration. You go to a probation officer maybe once a week, maybe once every 2 weeks, maybe once every month. Maybe after a period of time you don't have to report at all, but you're still under that probationary supervision. It's the most common and the most basic type of probation. The next type is very similar to straight probation, but it's suspended sentence probation. This is where the judge sentences an individual to a period of incarceration and then suspends that sentence based on their participation in the probationary process. It's just creating a situation where it is easier to incarcerate that individual if they don't meet the standards of probation. The process for incarcerating a probationer is often very involved if they are on just basic straight probation. More actors have to be involved in the process, the probation officer, the judge, any investigative resources on the part of the prosecutor. When you have a suspended sentence situation, that sentence is there. So if they do not meet the conditions of the probation, that sentence will immediately take effect. The next type is a split sentence. This is where the individual is sentenced to a period of incarceration and then sentenced to a probationary period after that. It is conceivable that someone could be sentenced to a period of incarceration, be released on parole, which we'll talk about later, finish their incarcerated period of time in the community while on parole, and then have to switch over to their probationary period. It's not uncommon to see a period of probation added on at the end of a period of incarceration. Sometimes, if it's the result of a plea bargain, The amount of time spent incarcerated versus the amount of time spent on probation can be negotiated. Uh, Typically, in those scenarios, you would have a shorter period of incarceration followed by a longer period of probation, but it really just depends. Additionally, if someone is convicted through a trial, the judge can impose a period of probation after the sentence. This this was evidenced in a sentencing that took place the day before I'm recording this. Harvey Weinstein was sentenced to 3 separate sentences. He was sentenced to 20 years. He was then sentenced to a consecutive period of 3 years, and then 5 years of probation following each of those sentences. So he has a potential 10 years of probation after a potential 23 years of incarceration. The next type is shock probation. This is typically invoked for younger offenders, first-time offenders that may be guilty of a serious offense but have factors that might come up in the pre-sentence report that would lead the court to engage in this type of probation. What shock probation means is that the individual is found guilty. The judge then sentences them to a period of incarceration. Following a 3, 6, 12-month period of incarceration, the offender is then brought back before the court and asked basically, how do you like prison? And most people don't care for it very much. The judge then gives them the option, if they have had good behavior, positive results, positive reports, at least in the correctional setting, to spend the rest of their time on probation. They don't know that they're going to have this sort of similar to a split sentence process. They think that they're going to have the full incarceration, and then they're given the option to serve it the rest on probation. The difference between that and a parole from an incarcerated release is that being on probation, the probationary period is monitored by different officials than parole. The last is residential probation. This is where the individual has to live in a basically like it's similar to a halfway house, but those are typically used for individuals exiting a correctional setting to reintegrate themselves back into the community. This is more just sort of a split between letting them individuals live freely in the community and putting them in an incarcerated setting. You're putting them in a required living situation where they can usually have some free interaction with the community, but there are a lot of restrictions that are placed on individuals in a residential probation setting. Things like refraining from drug and alcohol use, a curfew, maintaining employment, avoiding contact with criminal elements. The functional objectives of probation, there are 3 main ones. The first is to assist the court in sentencing through the pre-sentencing reports. Also potentially in a probation revocation hearing, where the person might be not adhering to the conditions of the probation and thus have a resulting period of incarceration. Probation also offers community protection while not keeping an offender in a correctional setting. It does offer a situation where they're being monitored by a criminal justice official. Their actions are being reviewed. They're held more accountable for antisocial behavior that they may engage in. And it just offers a way for the system to still monitor these individuals in the community. Lastly, it offers the offenders a chance to improve their situation. Being incarcerated is very disruptive towards one's life. Living situation, employment, things of that nature can be disrupted very quickly with a period of incarceration. Having a probated sentence allows the offenders to maintain their position in the community to some degree, while also maintaining supervision over the individuals. Um, the goal of the probation officer originally should have been and was to push the offender towards improving their lives through education, through uh, maintaining gainful employment. A lot of things were initially part of the role of the probation officer, and that's what we'll look at next. So the original origins of probation have religious ties, that members of the church would um, basically go to bat for a person that was facing a period of incarceration. Um, so they would basically act as their probation officers. They would be the ones to monitor them, to review their behavior, to set any benchmarks, and to make sure that the individual was engaging in actions that would better themselves, or at least address the problems that brought them to be in the situation that they were in. It was also seen as a way for judges to steer people away from incarceration. As bad as jails are today, jails 200 to 300 years ago, and jails and prisons were even worse. Very unsafe environments, very unsanitary environments, a lot of disease. That's one of the things that gets left out in a lot of reports of history and major historical events. The sheer number of individuals that die from unsanitary conditions, and jails have been historically places that fostered those conditions. One of the first, he wasn't necessarily a formal probation officer. That role didn't exist necessarily at this time, but he was one of the people to sort of try to formalize the process. John Augustus was a shoemaker in Boston in the 1800s, and he would go to court and see these people that were facing trial, and he would basically get the court to allow him to be a guardian of that individual until they were going to have the trial process. So this was a process that was working before the trial as opposed to after the trial. While they were awaiting trial, he would teach them his trade, the cobbler, shoemaker, and then when it came time for the individual to go to trial, he would speak for them at the trial and discuss their gains, losses, how they were handling the process, what they were going through, and then give his recommendation to the court in that way. We didn't see the process formalized and the role of a probation officer until a little while later, about 100 years later, in the early part of the 1900s, where we see the considerations looking at the social place of the individual, the psychological mental health of the individual, really delving deep into what the causes of this criminal activity was. As we move into the 1960s, we see probation officers trying to offer social services to probationers, in continuing education programs, still maintaining a check and a sort of checking the temperature of their mental health, their social place, their ability to get a job, have housing. Then as we move into the 1970s and sort of the nothing works era of corrections in regards to rehabilitation, we see a lot of reduction in the average spending per probationer. We see the probation population expanding, so the probation officers are very overworked, and we're at the position where we are now. We arrived back then to where it's basically just risk management. The probation officer is there to see if they can discern if any of the individuals are um, likely to commit more offenses, likely to become a social problem, and to minimize the future harm that they might do. Because of the sheer number of probationers that one officer handles nowadays, much like with the public defenders that we saw, there's not much social or psychological counseling that they can provide. Some of the foundations of the sort of the philosophy of probation. Um, the first is that not all offenders are dangerous. Uh, a lot of offenders will commit one act, and then once they see the repercussions of the system, they might never get in trouble with the criminal justice system again. That's not necessarily the case for incarcerated offenders. As we've seen, the reincarceration rate for offenders released from a correctional setting is about 2/3 after 3 years. So 2 out of every 3 people released from prison will go back within 3 years. Probation is trying to avoid that process. So not all offenders are dangerous. Not all offenders deserve to go to a correctional setting, because that can have intensely negative effects. We also want to maintain that level of community protection, maintain the level of supervision over the individuals, also offering them a chance to rehabilitate themselves. Though there's not much opportunity afforded on the part of their probation officer, especially with the development of privatized probation, that is still part of the process. And for some offenders will rehabilitate themselves. They will take the process to heart, and not commit bad acts, antisocial acts in the future. The role of a probation officer is a complex one. They have to be an enforcer of the laws. They have to do things like drug screenings, hold people accountable for their actions and their failure to meet certain aspects of their probation. But they're also supposed to serve as a counselor, someone to offer advice, someone to guide someone towards social services that they may have access to. But again, because of the sheer volume of probationers that individual officers handle, that has become less of a facet of their job. Much like the decision to place someone on probation, the goals of probation are such that they help to reduce the overcrowding in institutions by giving the court an alternative sentence to impose as opposed to incarceration. It's a much cheaper process than incarceration. Having a person in prison costs between $30,000 and $60,000 a year just for a basic prisoner, depending on what state you're in. A probation officer is probably making that same $30,000 to $50,000 range per year, and they might review, hundreds of probationers. So the cost effectiveness is clearly evident when we look at the cost of incarceration versus the cost of probation. Lastly, not all offenders are dangerous, but all prisons are dangerous. Prisons prisons in the United States are very violent places. They're rampant with drug use. They're rampant with financial, physical, and sexual assaults that take place there. And certainly all people that are convicted of a crime do not need to go to that type of a setting. The stages of probation, as the process plays out, first, following a conviction or a plea of guilty, a person is placed on probation. There are various conditions that can be placed on them: drug tests, community service, drug and alcohol counseling, or other classes associated with those substance use behaviors. But the person is placed on probation and given those lists of conditions that they must follow. Next is the supervision of the probationer. That typically involves meeting in person with a probation officer, It could be weekly, it could be every 2 weeks, it could be every month. It just depends on the circumstances as laid out by the court. Additionally, once a probationer completes all of the ancillary conditions of probation, they can oftentimes go on what's called non-reporting status. They are still on probation under supervision of the correctional system, but they don't actually have to go and physically report to the probation officer. Once all of the conditions have been met and once the time period has expired, there is then a termination of services. The probation officer finalizes the paperwork, submits everything to the court, which then registers the sentence as being satisfied. Parole, while in practice seems very similar to probation, actually has quite a number of differences. The first one is when parole takes place versus probation, and we're basically going to be comparing parole to straight probation. Probation occurs instead of a period of incarceration. Parole happens after a period of incarceration. It is a conditional release from prison. For all intents and purposes, the person is still incarcerated. They're still subjected to the reduction in civil rights and civil liberties that people inside of a prison face. They're just allowed to finish their sentence in the community. The main focus of this is to allow for reintegration into society, to have the individual being monitored and then review their behavior during that parole period, to gauge that individual's ability and potentially bolster it through programs and services, their ability to remain a contributing member of society. Additionally, parole offers the government a way to reduce overcrowding in prisons when those conditions are such that new space has to be made for new incoming convicted individuals. The safety valve of parole is there to let the low risk individuals that would be being released soon, release them on this conditional terms early. Further, as was the original intent of a parole system, which was created really in the middle part of the 1800s in the Elmira Reformatory. We'll talk more about the history of prisons and jails in later sections of the correctional section of the course. But it gave inmates something to strive towards. It gave them a reason to not commit further antisocial behavior once in a prison setting. There are a lot of types of antisocial behavior that can occur in a prison setting. So having the hope of parole gives inmates a reason to behave well. Much like with probation, parole has its own process. The two major steps are the parole release. That is reviewed by a parole board. In some states, that board also handles things like pardons, which is the case in Georgia. We have a board of pardons and parole. So they hear the parole hearings for the individuals and decide whether or not they are to be granted parole release. If they are granted parole release, they are oftentimes given a series of conditions, much like in a probation setting, that they have to follow and adhere to maintain their status on parole. That status is and the adherence to those conditions is monitored during the parole supervision. That is handled by a parole officer. A parole officer and a probation officer have a large overlap in the services that they provide. Um, they are supposed to direct individuals towards social services that they have access to, while at the same time monitoring their behavior and monitoring their adherence to the parole conditions. The two major types of parole that we have are straight parole, much like straight probation. That's what you might have seen in films or in documentary depictions of individuals leaving prison. Um, they meet with the parole officer, they adhere to the conditions. The other type is residential parole, where they leave the prison setting, they leave the correctional setting, and then move to what we would call a halfway house, where they have residence, a place to stay. Oftentimes, there's a certain services are provided there, food, other access to basic human needs. Um, there are a lot of conditions that are placed on individuals in residential parole, similar to the ones on straight parole. Obviously, you can't engage in drug or alcohol-related behaviors. You're not supposed to congregate with other convicted felons outside of the residential parole setting. But it offers individuals that don't have a stable living environment to go back into an opportunity to reintegrate themselves in the community. Also, for individuals, some individuals get sent to these residential parole settings, even if they do have a stable housing environment, but it's a situation that allows them to, like I said, reintegrate themselves into the operations of society. We've discussed these things in the past, but or in the earlier parts of this lecture, but we'll go over them here as well. Some of the major differences between probation and parole. Parole is not based on the court. It is based on the decision of the parole board, which is a member of the Department of Corrections. Parole is for individuals leaving a sentence as opposed to being part of the directed sentence from the court. Again, parole is determined by the corrections department, not the correctional system, not the court system. Probation is a directed sentence to community supervision, again, as opposed to parole being a conditional release from a correctional setting. Probation can be revoked by the court or the probation officer, depending on the circumstances of what is coming to their attention. Parole is revoked, again, by the same board that grants parole. So they are the ones that deal with people coming onto parole. They formalize the process for people completing the parole, and then they also review parole revocations. That agency that reviews the parole process is the parole board. They select and place prisoners on parole. They control parolees in the community through the parole officers, through the conditions that are placed on the individuals. Like I said, they are the ones that formalize the process by which individuals leave the parole system. Once the time period has elapsed, if all the conditions have been met, there's been a good history of participation with the process, then people can be removed from parole. They also review the parole violations and decide whether or not those are going to be serious enough to revoke someone's parole and send them back to a correctional setting. If that happens, then that person will go back to the correctional setting for the remainder of their sentence. There is no opportunity for second parole from a sentence. If you have parole revoked, you are more than likely going to serve out the entirety of your previous sentence. In addition, if someone were to commit a new offense on parole, oftentimes instead of prosecuting the new charge, again, depending on the seriousness of the offense, many jurisdictions will then allow the parole board to revoke the parole, and use that as a way to punish them for the new offense. It's a much more streamlined process than actually going through the whole court system again. The eligibility that people have for parole is based on a few things. First, there are an increasing number of legal restrictions placed on when someone can be placed on parole, depending on how long they've served their sentence, the percentage of the sentence that they have served, and also what the crime that they committed was. So certain crimes have less opportunity for parole. In Georgia, we call those 7 deadly sin crimes. The most serious offenses, basically like the index offenses from the UCR. If you commit those, then you're going to have limited access to parole. There's also what we call truth in sentencing laws that mandate that people convicted of these particular offenses have to serve 75, 80, 85, 90% of the time that they're sentenced to, depending on what the circumstances are, what crime was committed, and what the statutes say about that. There is no right to parole. It's not in any sort of constitutional requirement. Like I said, it was a product created of the correctional system to reduce overcrowding and to give the inmates a reason to engage in good behavior. Engaging in good behavior in a prison environment can oftentimes make someone eligible for parole earlier than just based on how many actual days the time period they've been in prison. The concept is called good time, and for offenses that don't have restrictions, based on the truth in sentencing laws, 7 deadly sin laws, individuals can receive basically 2-for-1 credit for the days served that they engage in good behavior. So someone serving a 10-year sentence with an eligibility for parole after 7 years that doesn't have any restrictions on the amount of good time that person can receive could conceivably be eligible for parole in 3.5 years based on the amount of good time that they can accrue. Once someone is actually facing a parole hearing, they go before the parole board. These are typically private, although there are some circumstances when parole hearings are made public for different reasons. It could be that the crime was especially wide-reaching and they want to have as many victims as possible have an opportunity to view the proceedings. Sometimes there's just a morbid curiosity on the part of our society. An instance of this was the parole hearing for O.J. Simpson in Nevada a few years ago that was televised because the whole O.J. original trial, his trial for armed robbery where he went to prison for, all of those things were carried out in the public view. So it just sort of made sense that his parole hearing would also be in the public view. Typically, though, the hearings are private. You just have the board, the inmate, a representative of the institution, an attorney for the inmate, the prosecutor might show up, the victim, if they are aware of the circumstances taking place, if they so choose, can come and offer a statement. But mainly just the people that have very, very first-hand knowledge of the crime that took place and the totality of the proceedings that have led to that point. A few other issues of regarding these alternative sanctions. The first one is the issue of mandatory release. If someone serves their entire sentence in terms of actual time served plus any good time, then they have to be released. There's not any policy to mandate someone being put on parole or having conditional release in those circumstances. If someone serves their time, then they have to be released. At the same time, if someone is placed on parole, there are a multitude of conditions that can be placed on their behavior. Some of those related specifically to the crimes they've committed. some of them related to other aspects of their circumstances, potential restitutions they might have to pay. The conditions that are placed on a parolee are very, very specific to the crime that was committed, and also the social circumstances that the potential parolee might find themselves in once they're released. We've really discussed previously the issues regarding violations and revocations of parole, mainly that there's not going to be any second chance at parole if you do have it revoked, and that it's oftentimes used as a way to punish individuals for new crimes they've committed without actually having to convict them of those crimes. It is one important thing to note. We discussed good time, that time period where you get double the credit for the days that you serve engaging in good behavior. There is also a thing called dead time. In between someone being arrested for a parole violation or potential parole violation, the time they spend incarcerated between that arrest and when the revocation actually takes place, they do not get correctional credit for that. They don't get credit off of their sentence for that. The length of the sentence, how much longer the person is going to have to spend incarcerated, is determined by when they go back to the correctional setting. So from the period of time when the person is rearrested facing a potential revocation, there is no credit for that time spent waiting in that period. And that could be days, weeks, months, depending on how backlogged the parole board is in hearing the issues regarding the revocation. So make sure to read chapter 12 of the text and further contextualize the major issues that are brought up here with what you read in the textbook.